made up from our
You
accident.
were at the Secretary of State's office, and you were at the clear, based upon what the court looked at, he has never had a Michigan
video. I wasn't in court. I wasn't even on YouTube.
December 28th, 23.
23rd.
People are saying, and quite frankly, your client has made the assertion that the Pittsfield Township, as well as this court, was acting on some type of defective or faulty information, which I will tell you, counsel, caused the court, given what the court did, to investigate what my ruling was. And I will tell you that that assertion is absolutely correct with reference to any faulty information that either came through to the Pittsfield Township Department of Public Safety or to this court ultimately at the May 15th hearing.
Let's pause right here because this is a powerful moment in the courtroom. The judge is addressing a serious accusation that the court acted on faulty information. Instead of brushing it off, he's doing something judges rarely do on record, breaking down every step that led to the decision. When a judge says the record needs to be very clear, it means he's about to walk everyone through the facts piece by piece, and by the end of it, someone in this situation is going to look very different than they did at the start.
And I think it needs to be stated, I've been asked for comments. I have refrained from comments, as is my normal practice is. This court with the pending case will speak on the record. And so I am going to make sure that the record is very, very clear as to what this court knows and what this court acted on May 15th. And we can start with this. And my basis for doing it is because of what was said about what this whole process was. And that an indication, counsel, and I know, counsel, you've been before me before.
Absolutely.
I know it is not coming from you, but you also know how I am.
I do.
And the thing is that if for whatever reason, the one time in my life I was wrong, I will say it and did. But when I'm not wrong, and when people are not to blame, then it also needs to be said. So I will try to get through this as quick as I possibly can. But I will tell you, first of all, with any reference to your client having had a license on that day, and some indication or misunderstanding as to whether or not he had a license. Let me make it very clear, based upon what the court looked at, he has never had a Michigan license, ever, and has never had a license in the other 49 states and commonwealths that form up this great union. He has never had a license. In point of fact, when they suspended his license, and what people don't understand, when they suspended his license in Saginaw, they don't suspend the license. They suspend the privilege to drive in this state. Hence, for example, if he had had a Kentucky license, he would be able to drive everywhere that Kentucky would allow him to drive. He just couldn't drive in Michigan because his privileges had been restricted. I know you know that, but that wasn't at all said. But it doesn't matter because he didn't have a license. Ever. There is also then, and I will, when it is necessary, come to the defense of my sister courts, and I will come to the defense of Saginaw. They got a great chief judge. Chief judge answered the question. But I will tell you, that court and its friend of the court did nothing wrong. His license was, his driving privileges, better stated, were unsuspended in 2022. That required Mr. Harris to do something. He didn't do it. Therefore, that friend of the court was under no obligation to send anything to the Secretary of State. Now, I hated that I had to look at all of this, but when there's a question as to what I did, I'm going to look at everything to make sure that what I did was all in order. There's then an indication from that because that wasn't sent, there was a direct attack on Michigan's Department Secretary of State's office, saying that the Secretary of State was somehow at fault. Let me tell you something. Secretary of State did what they were supposed to do. And in point of fact, they did nothing because they hadn't gotten anything from the court because Mr. Harris had not paid the reinstatement. This week, or the latter part of last week, once he paid that, Saginaw friend of the court did what they should do, and they sent it. Immediately, based upon the information that I have, the Secretary of State did what they do every day. They took that suspension off of his driving record, and he was then unsuspended. And then your client did what he needed to do with reference to the Secretary of State and paid a reinstatement. Okay. Just a second, Mr. Schiller. I'm going to let everybody respond because
Thank you.
I am not done yet.
Okay.
All right.
You covered a lot of the points for me. Thank you, Your Honor.
And so that came down to that. So the information at the time that I had, that Pittsfield Department of Public Safety had, was all correct at the time of both Pittsfield stop as well as the May 15th date. It was all correct. There was no error by anybody. It was a failure on the part of Mr. Harris to do certain things. Now, I grant you that sometimes that can be a complicated process, but it was certainly not anybody's fault that that didn't happen other than that wasn't paid. Now, here's the other thing, and I'm like maybe in church where I say I'm about finished now, but the other part of this is this stop was in October. Most of the cases that we've heard just in this last afternoon are driving while license suspended cases. That's part of my Wednesday afternoon. We go through great pains to try to get people their licenses back, which is really how it should happen. Between October and because I don't live under a rock, I actually watch things. You look very nice on TV.
Thank you.
You're welcome. There was something that was said that was very disturbing to me. And I'm just going to let you know because I believe in being fair with everybody. The question was asked along the lines between October of 2023 and the point in time of the May 15th hearing, was there an attempt by Mr. Harris to correct his license? Here's the part that was disturbing for me, so that you know.
Okay.
Mr. Harris indicated that at some point he had been involved in some accident. And being involved into the accident, that he was basically bedridden or at least housebound, he could not get to the Secretary of State. That was set up there, and I'm going to presume, because my knowledge of counsel, defense counsel is, I know you don't misrepresent anything.
Right.
You never do.
Right.
That's not true.
Okay.
He purposely stated that he could not get to the Secretary of State, which for the way we handle things in this court would have placed him in a whole different category. We would have tried to find a way, let's figure it out. And the reason I know that is because Mr. Harris, on December 28th of 2023, do you know where you were?
December 20th, 23.
23rd.
2023.
I know.
And this is the turning point of the entire exchange. The defendant previously claimed he couldn't get to the Secretary of State because he was injured and housebound. But the judge just revealed official records showing he actually visited the office months earlier to renew his ID. That kind of contradiction is huge in court. Judges rely heavily on credibility, and once a statement is proven inaccurate, it can change how every other claim is viewed. At this point, the courtroom dynamic shifts from questioning the system to questioning the story itself.
I was laid up from my
You were
accident.
at the Secretary of State's office. And you were at the Secretary of State's office because you redid and got your new Michigan ID. I have the date. That's the date you did it. December 28th, 2023. You did. And so that you also know, and in all fairness to counsel, because I don't know if counsel knows this or not, the way I know that he's never had a license is because May 3rd, 1990, he was 19 at the time. May 3rd, 1999, he applied for his first Michigan ID. Counsel knows, so I do. You cannot have both. You either have an ID or you have a license, one of the two. He has religiously every year gotten a new ID. And so he knows that he doesn't have a license. And quite frankly, I just wish he would have said that at the beginning. And all of this hoopla could have been just put all aside. And we all go through the process as we do with all of the people coming here to try to get him his license back. But his falsehoods, misstatements are not going to fare him well in this court.
We all saw this video. I wasn't in court. I wasn't even on YouTube watching the court today, right? I saw it because someone saw it and decided to post it. I can assure you that was not Mr. I don't think he has the capacity to be able to post it like that on YouTube or Instagram. So that was not him. And it happened to take off and go viral. So he had what we saw was him saying he was driving, which he should not have been driving, right? We're told not to drive on Zoom while doing that. So that's how this came to the attention, because the court, I saw you. He said, I can't believe this. Is he driving? And we all said that. Everyone who saw that video asked the same question. And that it became a joke. It became a complete joke. Now, with respect to what we want to do, and I cannot say anything is with respect to what my client has said, but when we talk about the hoopla, my client didn't start the hoopla. Perhaps he's made some comments, but he didn't start the hoopla whatsoever. That was someone that was outside of his control as to how it went viral. He had no control over that, and that I'm going to stand on that. He did not send it out to Instagram. He didn't send it out to wherever. He didn't do that part. So, with respect to, did he have I don't want to try this case today at all, but what I want to do is focus on what's good. Now, what was good? That day in October, this officer here, that could have gone a whole other direction. And I'm so happy that you were so kind and courteous to my client. Thank you, officer. Thank you so much, because it could have gone another direction. We are here right now. My client has an appointment to go to the Secretary of State for his permit. He's working on that. I want to focus on how do we correct this and cure this? How do we go forward with this situation? Whatever, he was not under oath under any of the things that he said. So we're not talking about any type of perjury going on. Very true, right?
True.
So with that being the case, let's move forward with this. He is here. This is what I'd like. Because
Counsel, let me just.
yes.
I would like to move forward too.
Yes.
On this case. We handle these cases all the time. But I will tell you, as you know, having appeared before me, the one thing I don't like is when people don't take responsibility for what they've done. When they take responsibility for it, we will use whatever we can to try to get you to another spot, because it doesn't behoove any of us for you to be in that spot. One other thing that I will say, when you say it wasn't started by him, oh, it certainly was. It certainly was when he made his first statement to WXYZ about blaming people for this happening. And he shouldn't have done it, because when you look at the whole thing, the person that needed to be blamed, and we can go back to a lot of other points, but I'm not here to embarrass it, but the person that needed to be blamed is the person that he was staring at in the mirror. He didn't do what he should have done.
What we're looking for, because there are some options here. My client has indicated to me and would like me to indicate to the court that he is in the process of procuring his license. Oh, hopefully that privilege will be available to him, but he does have, as you stated earlier, and I have the receipts, he did pay the reinstatement fee. Those fees are paid. Anything that was out in the previous court, those fees have been paid, and I've been presented with those receipts. In addition, on tomorrow, he's got his permit test coming up, and then after that, because he's an adult, he's working on it so that he can take advantage of the offers that are available. Because as you say, this court does want to help. Absolutely. And with that, because my client was in an accident, and I haven't seen the medical records, but because of some of the things it could be, I don't know. But sometimes our memories get a little foggy. Now, am I going back to 1999? No, I'm not. But I'm just saying that I'm saying from this day forward, he is working diligently to take the steps necessary to get this driver's license so he can take advantage of the generous offer.